on this episode of Law Weekly, a conversation with a senior legal practitioner, GT Ogunye. We talk about the moves by the president to increase the salaries of judicial office holders and the complaints in some quarters that the newly proposed figures are not reasonable. Is this also a good time to remove the judicial immunity from prosecution that 7 judges enjoy? Also showing on the program, Legal Aid Council seeks support of critical stakeholders, takes campaign to Plateau State. Plus our recap of the top trending stories in the courtrooms. Hello and welcome to the program. I'm Shola Shoyele. Now, it's no more news that the House of Reps has passed the executive bill by President Bola Tinubu to increase the pay of judicial officers nationwide. The bill seeks to amend aspects of the Certain Political, Public and Judicial Officers' Salaries and Allowances Act and could see the salary of the Chief Justice of Nigeria jumping 800% to 64.6 million naira per annum, while other Supreme Court judges will earn 60.47 million naira. This pay rise trickles down to every cadre of the judicial sector. Now, while the move has been commended by stakeholders in the judicial sector, it's been condemned by others outside the sector who thinks it's reward for the roles the judiciary played during the 2023 general elections and for the roles they're expected to play in future elections. But there are also some judges and lawyers who think that the figures being bandied about are not far-reaching enough, especially when one considers that the last time salaries of judicial officers holders was increased was in 2008. They say it's not reasonable considering the state of the economy, the rate of inflation, the rate at which dollar is exchanged to the naira, and that it is even a far cry from what judicial officers in Commonwealth countries earn. Now, this is the starting point of my conversation with senior legal practitioner GT Ogunye.
The factors enumerated, namely the exchange rate regime, the rate of inflation, the comparative salaries and emoluments of judges from other Commonwealth countries and common law traditions, and the state of the economy. Yes, these are good reasons to have a realistic fixture this time around. However, we need to stress that just as what was done in 2008 appeared solid, but in no time, proved to be inadequate, what may be fixed now, may also be gutted by inflation, economy, and so on and so forth. So, I call therefore for a systematized increase. And this will be an outcome of a robust debate and not just an offshoot of the weaving of the wand of presidential altruism. And so that will mean that when we conduct that debate and these critical factors are taken into consideration, we will arrive at a figure that will be put on a grid or table so that as the rate of inflation is swinging like pendulum, these fixtures can be adjusted on the scale. I've called for this before, so that we won't have to come again and again to be adjusting salaries and so on and so forth. For example, if the economy of Nigeria were to improve and the exchange rate were to become more stable, and that, the rate of inflation drops, will anybody be advocating that any salary regime for judicial officers that might have been fixed now should then be revised downward? Will anybody be suggesting that? No, nobody will be suggesting that. That's why we call for a realistic adjustment that will reflect the totality of these factors and which can then move up and down that grid or scale. But beyond that, for those who may just be saying, oh, this is not sufficient, what the president has done is not a reflection of the aspiration of the legal community, lawyers, judicial officers, and all that, who have been drawing attention to this for a long time. We will need to do some kind of contextualization these judicial officers are Nigerian judicial officers. So what is the state of the Nigerian economy? What is the salary, expectation of professionals? Granted that judicial officers offer a special service to the country, but doctors can also say so. Academics can also say so. Policemen can also say so. Military officers or soldiers can also say so. Indeed, they can say that they put their lives on the line every day and they may be killed. So there can be justification across the sectors, infinitely. Therefore, judicial officers, lawyers must care about Nigeria. They must care about Nigeria, that these adjustments, as desirable as they may be, can only be best guaranteed in a Nigeria that is better, in a Nigeria that is prospering economically, in a Nigeria that is socially stable. And that without this, if you want to now create an island or an oasis of remuneration or remunerative comfort for ourselves because of the special service that we render, there may be a disequilibrium in the system. So we need to think wide and big and then wish that our country is better than it is.
Still talking about money, I hear what you say about the need to consider the state of the economy as at present, but the bill seeking to stop payment of pensions of former governors and their deputies that are National Assembly members. Some lawyers say that the bill and the debates on it by the National Assembly are unnecessary attempts to usurp the powers of the state houses of assembly to make laws.
For some time now, the salaries and pensions and allowances of former state executives in the country, governor, deputy governor, etc., that matter has been an issue that many are debated. The anger is not only about the humongous nature of these pensions, but also about the double portions of those who may be concerned. Some of them are living at their states and they become federal ministers, they become federal legislators, and they also draw salaries. So they start drawing money from both ends. And then for the former, they draw it till the end of their days for life and all that. I think that this is what actually rankles. And so for me, it's a matter that the National Assembly need to care about. Now, it is true that we run a federation or we run a unitary system masquerading as a federation, depending on how you look at it. But in spite of what we have, under the Constitution, it is within the legislative domain or province of the state to legislate on matters like allowances and remuneration for their respective former political office holders. And so it's a matter that they have to be concerned about. And not just for the optics, but because we are talking about good governance, we are talking about better society. And, it is not right for resources of states to be fleeced, for resources of state to be stolen in the name of, remunerating past office holders. So it's a concerning matter. And being concerned about it, therefore, they will need to answer some questions. First, this matter that they want to dabble into, do they have the legislative power to dabble into it? They may have the legislative power to dabble into issue of remuneration of federal political office holder, the president, and the exercise powers in that regard. Now, can they have a law of general application? What does the Constitution say? And all that. Yes, they have the power to legislate for the entire country. What is in doubt is whether they have the power to legislate specifically for a state, thereby attempting, as it were, allegedly to usurp the powers of the state's House of Assembly. I will cite a case for a guide. And that case is the case of Attorney General of Ondo State and Attorney General of the Federation in 2002. The first legislation that the Obasanjo administration supported was the ICPC Act. And that act was passed. But state executives were challenging the constitutionality of that law. And the argument was that corrupt practices or corruption is not covered by the exclusive legislative list. It's like a criminal offense to be defined in the criminal code of every state, and therefore the federal government should not legislate on it. And the matter went to the Supreme Court, and the Supreme Court held in that case that corruption has become a national malaise. It has become a national problem. So much so that the Constitution referenced it in Section 15(5), when it provides that the state shall abolish all corrupt practices and abuse of power. And that being so, the National Assembly, for good reason, can legislate for the entire country. And so that law was saved. It was not struck down. And, the law continued to operate. And it was thereafter the FCC Act also came. And the FCC also had similar challenges. Therefore, I think that the issue of remuneration of past political office holder across the country by state government haven't become a major issue in Nigeria, which is very concerning. The National Assembly as a whole, in my view, may look at it and create a kind of norm, and then answer the question whether it is indeed desirable to remunerate past political office holder. I don't think so, because they are not career public servants who are entitled to pension. Somebody came to office and spent 4 years as a political office holder. So what are you giving him pension for? For life. What are you giving him pension for? And many of them are still very active. Inevitably, when they become governor, they want to become president. When they become governor, they want to become senators and so on. So why do you then need to remunerate them? I think that the National Assembly, in discussing this matter or in making an enactment, must not just face one way. The National Assembly can legislate. It's not always for, yes, to prohibit it and say that no, this cannot happen. Not at the state level, but I reckon that having tolerated it at the national level, the likelihood is that they want to do something at the state level that will be uniform, But states where the internally generated revenue currently is so paltry, is so poor, certainly, inevitably, may have to have recourse to fact account, federal allocation, to even pay that kind of money that we're talking about. So why do you need to take money from the center and then use it to pay yourselves after you've left office? I think that it's too much a burden for the people to bear at this point.
I hear what you say about corruption, that it has become a national menace, which the courts took judicial notice of. But in relation to the question that I asked earlier about judges, does it not make sense that as the country moves to increase the remuneration of judicial officers, we also remove the immunity that they enjoy? That one that says that until they are investigated and removed by the NJC from the bench, they can't be prosecuted for corruption.
That makes a lot of sense, but there's a caveat here. Jumbo pay alone, standing alone, will not insulate judicial officers from engaging in corrupt practices. I mean, there is no empirical data to support such a view. I think that the judiciary, and in particular the Supreme Court, did a great harm to the fight against corrupt practices in the judiciary by giving themselves that decision on immunity. And what was the decision? That for any judicial officer to be investigated and arraigned in court, he must first have been investigated by the National Judicial Council, disciplined, and removed from the bench before you can proceed against him. In their own thinking, they felt that the judiciary would be subjected to untold ridicule if serving judicial officers were to be investigated and arraigned in court. I disagree with them because the law does not say so. The Constitution did not say so. The Criminal Code has provisions for arresting judicial officers. It's there until that decision came. And there is no provision of the Constitution outside the provision on immunity, Section 305, on immunity for president, vice president, governor, deputy governor. Judicial officers, in Nigeria didn't have such an immunity. So what the Supreme Court did in Nigerian is to do that. Now, having done that, is it advisable to have a legislation to overturn that Supreme Court decision? Some of our colleagues, they say no, that would be disrespecting the judiciary. But look, that decision was a self-serving decision, and the legislature can look at that and say, if all these things are being done and we have judicial officers who are on the radar, okay, just like politically exposed persons, okay, because usually when you are talking about corrupt practices, unless there's a problem in the chain, the giver who is favored by a trial outcome will not talk, and the taker will not squeal. So it's a quid pro quo, and there is silence forever, right? It is difficult to then get the person who is holding the shorter end of the stick, may be, imagining things, maybe speculating, but he has no hard evidence, he has no proof. And so the anti-corruption agencies can then use technology, modern, investigation devices to eavesdrop. You can't do wiretapping, to pry into accounts of spouses, of children, to look at, lifestyle. Cannot even do that because it's not an offense yet. And it's only when a petition is done, against a judge, that you then have an investigation. Whereas, anti-corruption agencies generally, including the police force, can apprehend criminality. It is basic that it is not when a crime is committed first that you can apprehend it while that crime is being committed. So in this case, it is said that you must first file a petition. So if no petition is filed, nothing happens, and the game goes on. There's a problem with that.
Thanks for staying tuned. The Legal Aid Council has identified the administration of criminal justice system as a catalyst to justice delivery to all Nigerians, irrespective of status and class. The Director General of the Council, Aliyu Abubakar, stated this in Jos, that the Legal Aid Council plays a pivotal role in providing necessary defense required to indigent people in legal matters, and especially will aid the decongestion of prisons across the nation. We have this report up next.
As part of efforts towards executing its mandate to provide free legal assistance and representation, legal advice and alternative dispute resolution to indigent Nigerians in conflict with the law to enhance access to justice, the leadership of Legal Aid Council of Nigeria visited Plateau State, where one of its operational bases is domiciled. The Legal Aid team proceeded to the Government House, where the Director General solicited for the continuous support of the government as the Council embarks on fulfilling its mandate.
That between the year 2021 and 2023, we have been able to grant legal assistance to about 2,500 persons in the state. We will continue to serve the state and the nation by providing succor to those Nigerians who are poor, so that they could be able to access justice and ultimately justice as much as we can. Justice, and especially criminal justice system, is the bedrock of every civilized society. We must, as a country, strive to comply with international rights, human rights standards, especially in the operation of our criminal justice system. The Legal Aid Council is a necessary vehicle for access to justice. Our services are a social service akin to all governmental interventions intended to uplift and assist a larger proportion of our citizenry who are poor and indigent.
Governor Caleb Mutfwang assured of government synergy with the Legal Aid Council in the administration of criminal justice, especially in the area of prison decongestion, which has been a major challenge.
Rest assured that we want to have a very robust justice sector. And of course, a key component of the justice sector is the reform of the administration of criminal justice. But let me say this, that we need to take the matter of prison decongestion more seriously. And I think it's a question of synergy between the Legal Aid Council, the Office of the Attorney General, and of course the Chief Judge of the state. We need to have that synergy and make sure that we are more deliberate and intentional in trying to decongest the prisons.
The Chief Judge and Chairman Plateau State Judicial Service Commission, Justice David Mann, received the team in his chambers, where he assured the team of cooperation towards effective and efficient justice delivery.
We on our part received maximum cooperation from your staff that are resident here. As a matter of fact, Mr. Egege has been regular in appearing before me in a number of cases, some of them quite sensitive, and of course, like you mentioned, we have partnered in other responsibilities, such as
The Director General further enumerated the importance of the Council towards achieving the effective administration of criminal justice system.
As far as our criminal justice administration is concerned, I must say that the Legal Aid Council has continued to play a pivotal role in the sense that we have always been there to be able to provide the necessary defense that is constitutionally required by the Constitution of the Federal Republic of Nigeria, 1999, as amended, to the poor and indigent who cannot be able to afford legal practitioners of their own choice. So I must say that we have done well, and we are doing well in terms of the number of people that we assist in getting justice.
There is no doubt that the Legal Aid Council's assistance to indigent Nigerians, especially those who cannot afford services of council representation, is vital in the administration of criminal justice system in the country.
And just before we go, a quick recap of some of the top legal stories in the news.
We begin with the report that the arraignment of Binance Holdings Limited, one of its senior executives, Tigray Gambarayan has been stalled at the Federal High Court, Abuja. The arraignment could not go on as the second defendant, Mr. Gambarayan, had not been served with the charge by the Federal Inland Revenue Service. At the proceedings, his counsel, Tonya Krukrubo, told the court that his client does not have any idea of the charge against him. The opposing counsel to the FIRS said this was because the defendants had been in custody and it was difficult to serve him with the court papers. He asked the court to grant leave so the defendants could be served in court. The court granted the request and ordered that the defendants be served in court. Still at the Federal High Court, Abuja, Justice Donatus Okorocha has awarded the sum of 5 million naira as damages against the Economic and Financial Crimes Commission, EFCC, for wrongfully parading a photographer as a fraudster. The court declared that the EFCC should remove the image and name of the applicant, Nasiru Saidu, popularly known as Ali Gozo, from its Instagram page and other social media platforms. The court also granted an order of perpetual injunction restraining the EFCC from holding the applicant as a fraudster without the judgment of a court of competent jurisdiction. At the Chief Magistrate Court, also sitting in Abuja, the Inspector General of Police has summoned 5 social media users for criminal defamation of the reputation of gospel singer Mercy Chinwo and her husband, Blessed Uzochikwa. In the court summons dated April 3, 2024, Chief Magistrate Emmanuel Iyanna ordered the 5 defendants to appear in person before the court on April 23 to answer to the charges of defamation leveled against them. The suit stemmed from posts made by the defendants last week after the gospel singer and her husband posted a picture of their son on Instagram. After the picture of the baby was posted, the defendants alleged that there was a resemblance between the baby and another gospel singer, Nathaniel Bassey, and claimed that he was the father, an allegation that went viral. In a criminal complaint filed by the complainant's lawyers, Mercy Chinwo and her husband said the actions of the defendants amounted to cyber intimidation, injurious falsehood, and cyber stalking targeted at their persons. And we round off with the report that controversial cross-dresser and social media celebrity Idris Olarewaju Okunoye, popularly known as Bob Risky, has been arraigned by the Economic and Financial Crimes Commission, EFCC, at the Federal High Court, Lagos. When the charge was read, Bob Risky pleaded guilty to the first 4 counts bordering on naira abuse. When Bob Risky was asked if he understood the charge that was read to him, he replied, quote, "Yes, I am guilty." Before the charge was read, however, the EFCC's counsel, Suleiman, asked the court to strike out counts 5 and 6, bordering on money laundering allegations. Justice Abimbola Awogboro subsequently struck out counts 5 and 6. This paved the way for the arraignment of Bob Risky on only counts 1 to 4.
And this is where we adjourn proceedings for today. Do remember to check out the Channels TV website for a replay of this episode of the program, as well as past episodes. Please also send in any feedback via our social media handles. I'm Shola Shieli. Thank you for watching and see you next week.